Hey guys, I'm Karina.
And I'm Eric.
And welcome back to the Late Podcast. The law according to Eric. All right, so our topic for today is bankruptcy fraud, which in my research, it just said it's a federal crime that occurs when someone intentionally takes action to hide assets or provide false information during the bankruptcy process. And then the goal of the people is usually to get an advantage in the end.
Yeah, that's a very simple explanation, but generally speaking, yes. There are many types of bankruptcy fraud or fraudulent activities within a bankruptcy. The most common is what's known as intentional omission, which essentially is a fancy way of saying that somebody filing bankruptcy wishes to hide or not report a certain asset they owned out of fear of losing the asset or having it sold or liquidated by a trustee.
Right.
So they act like they don't have it. That kind of thing has happened a bunch of times. It doesn't always rise to criminal activity. And even an intentional omission often will be met with what's called a denial of discharge. So it's not necessarily you're going to go to jail, but you basically have filed bankruptcy for nothing because you'll lose the asset anyway, and you still won't be able to wipe out your debt. So it carries a pretty stiff penalty, even without the prison time.
Right.
But bankruptcy fraud can be a criminal offense, can be punishable up to 25 years in some cases.
Yeah.
So yeah, it's an ongoing thing, and there's all different levels of it, from the highly sophisticated fraudulent schemes to essentially stop foreclosures and lots of different fraudulent ways in which that happens, to sort of unsuspecting patsies that have been taken advantage of by fraudulent activity conducted by organized crime rings,
right?
That find themselves in bankruptcy. I'll tell our listeners a story about that.
Okay.
There was an individual that came to see me maybe 10 years ago who had close to $85,000 in credit card debt, unpaid credit card debt. So in any Chapter 7, where we're basically going to just try to wipe out all the debt, there's no assets. Right. He doesn't own a house. He didn't own anything fancy, no special jewelry, anything like that. We have to still go through the intake process. Right? Where do you work? How much do you earn? So the guy worked at the time at a car wash, and he made like $12 an hour.
Wait. You've told this story 2 times, right?
On this podcast?
Yeah.
Oh. Okay, well, basically...
You want me to cut it out? Or
It's okay, thank you. I forgot. But basically, it's just the guy was being used by the Armenian mafia to basically take out a bunch of credit cards, cash advance them. The guy got a few $100 each time, and then he was told just go bankrupt. And that was a big, sort of fraud. And unfortunately, he had 2 choices. He can either just cop to it and hope he doesn't go to jail himself, or he'd have to basically testify against the Armenian mafia, which may get him unalived. So there you have it. There's other better examples, but since I already wasted time on something I already said, we can just move on.
I was going to just cut it out, honestly. I didn't want to.
No, I think the whole beauty of our little podcast is it is uninterrupted, live, unedited, right? What you hear is what you get. So
I had 2 questions regarding bankruptcy fraud that I saw that popped up a couple of times. The first one that I kind of never heard it happening. But what would happen if someone who was filing bankruptcy listed something as an asset, but it wasn't theirs? What is a penalty for lying about an asset?
Well, that's a harder question to answer. That's typical of this sort of foreclosure fraud, where you'll have some weird trust, like the XYZ family trust, file a Chapter 7, and they'll schedule an address of a property that they really have no interest in. But that property was scheduled for foreclosure sale. And so these quote unquote foreclosure consultants, they take $300, $400, $500, $1,000 from some poor unsuspecting family that's about to lose their house. Don't worry, we'll stop the sale. They don't explain to them that they're filing, a bunch of fraudulent bankruptcy petitions or giving away fractional interests of property ownership to stop sales. There's a few different ways to do it. And I certainly don't want to encourage any of our listeners to do anything like this. But just for context. So yeah, that we see that kind of stuff all the time, unfortunately.
Okay. And then secondly, so I saw this story and it made me laugh, where she was trying to tip off the trustee that the bankruptcy was kind of like a fraud. But they were asking how anonymous can you stay when you tip someone off, or if there's a time period where you can go and tell them about what's going on.
Well, it's not a very intelligent question. So I'm sorry. Look, I've had cases where creditors have called the trustee and were like, "Oh, your client didn't report to you this, or this." Rather, the debtor, didn't list that, or the more common one is he lied. He really has more money, or he owns a piece of this other company that he's not disclosing. There, you can be anonymous, I guess. I mean, people can call in anonymous tips all the time, anytime they want. It's really the bankruptcy court's trustee or the bankruptcy trustee's job to, look into it. Yeah. There's no time frame as far as I know. I mean, you can reopen a bankruptcy case for something like an intentional omission at any point.
Well, hers was she moved/sold all of her assets and a business that was to like a very close friend of hers, and it was apparently so that she wouldn't have to pay like the financial obligations for the bank, and that's why they're doing it. But she knows this, and she wants to go and basically like tell the trustee.
Okay, so a couple of little flaws with that lady's description. Unless all of the bank loans or whatever are unsecured, meaning that the borrower didn't sign a personal guarantee, which almost never happens. Only like the largest, most profitable corporations have lines of credit where there's not some kind of personal guarantee. Right. Most small businesses cannot get small business funding or financing without the owner or the partners or whatever signing a guarantee. Right. So even if this lady sold off her business to a friend, quote unquote, unless she had no personal obligation, anything, then the bank would just come after her. Right. So that's number one. Number two, I'm wondering if the person posting this question is owed money by that lady.
No, she said her daughter's in the same sports as her daughter, and she's just overheard it. Like,
okay, so that's just
soccer mom drama.
Yeah, that's just somebody spilling tea or whatever. Yeah. I'm not. You know what? I'm not going to even bother responding. That lady can just wallow in her own misery.
And I feel like at the end of the day, don't they say like trustees find everything out? Like at the end of the day.
Well, let me put it like this: you are as a bankruptcy attorney, as a practicing attorney, I always assume that the trustees will find everything. Right. And I explain to the clients that there's a very good chance somehow, some way, whatever it is you think you're smarter than the trustee about hiding will come out. So if I know what it is and I know the value, we can work around it. We can offer to buy the estate's interest back if it's something super important to you. If it's worth up to a certain amount, but less than a certain amount, we can exempt it under what's called a wild card exemption, which literally is, I think it's like $25,000 of, you can literally exempt cash under your mattress. And, of $25,000, the trustee can't touch it. Right. As long as you're not utilizing your homestead exemption. So if you're filing Chapter 7 and you don't own a home, but you have like a Rolex that you got as a graduation present or something, you can exempt that. You don't have to lie about it. You can protect up to $25,000 worth of stuff, any stuff.
That's good to know for people because I feel like
I think that's the amount. I'd have to look it up. Honestly, I'm not in front of like my screen. But basically it's called in California, you have what's called the wild card exemption, and you can use it for just about anything.
Wow. Okay. So I think that wraps up us explaining it. Do you want to do the
let me explain it a little better than the textbook definition. Okay. Bankruptcy fraud essentially is any time a debtor in bankruptcy or a creditor misreports information intentionally. Let's just keep it simple. Creditors can be guilty of bankruptcy fraud too by filing, for example, a false proof of claim or claiming more money than they're really owed, hoping that, they get some kind of windfall. We've even seen that, which is like so ridiculous, right? Because you have to justify your claim, but people think they can get away with stupidity. So it happens.
Yeah, people think they're slick, and that's tells all this time. All right. So now we're going to do the What Would Eric Do segment.
Okay. What would Eric do?
But by the way, did you hear about that shoe store that burned down?
No.
Apparently a bunch of souls were lost.
So for
see, Jen laughed. Okay, my dad joke was good.
Okay, I know. Let me just we should have introduced it. Let me tell the audience. Every week we're going to have a dad joke segment. And so Karina has one and I have one. And honestly, my short-term memory is not very good today, so I forgot we were going to do that too. But here's mine. Where do you go to learn how to make a banana split?
Where?
Sunday school.
Oh my God. That was good. Oh,
thank you. So, and before I forget, I just want to say last week we had the best insomnia cookies.
Yes.
They were so good. And they had the Thanksgiving flavors of the gingerbread. Oh my gosh. And then I ordered more yesterday. No special reason. They sent an email with a deal: buy 12, get 12 free. Literally got 2 dozen for the price of 1 dozen, and they were amazing. Chocolate chip, peanut butter, snickerdoodle, the ginger ones, all of them. I'm serious, they're the best.
They're the best.
They're so good. I have tried multiple, like, because like gourmet cookies is like a thing now.
Yeah.
Right. They have crumble and milk jar. I've tried them all.
Yeah.
They all suck compared to, as far as I'm concerned.
By the way, he ordered milk jar when I wasn't here, guys.
But no, you're lucky because I didn't even want them. I literally I gave them to Jennifer's kids. We didn't want them. Like, I brought them home. Even my own kids didn't want them. Like, they're just they're. I don't like the big, thick, brick, bulky cookie. Yeah. Insomnias, first of all, are fresh. They're warm.
They're like those boneless cookies. Have you heard that term being when they call them all warm and like soft and gooey? They're like boneless.
But they have the right amount of like crunch on the outside.
Yeah.
Right. And they're flat.
Yeah.
Right. They're not bumpy and thick. So
crumble overwhelms me.
Yeah. The milk jar too. And what I didn't like about milk jar is they didn't feel fresh. Right. They were put in these individual wrappers. And that makes it feel like a supermarket cookie kind of.
7-Eleven cookie.
Yeah. And so we don't like those. So kudos to Insomnia. Hashtag Insomnia rules, whatever.
Yeah.
They're just really good. And I'm going to order another batch Friday for the weekend to take home because they're so good. But anyway, okay. So what would Eric do?
All right. First one. My friend plans on taking out a personal loan and then immediately filing for bankruptcy.
Stupid. Don't do it.
Is it as dumb
Stop.
as I think?
Yes. Stop.
My friend has a lot of debt, enough that filing for bankruptcy might be his only option.
Yeah, he should do it then without taking the loan. That's fraud.
Since he's figured he's going to need to file Chapter 7 anyways, he thought he might take out a $20,000 loan to pay off his rent for a year before filing.
Oh, is that all? $20,000
to have the debt washed. This would allow him to use what he has been paying in rent as a nice little safety net and possibly to invest in his future where he couldn't before. This to me sounds like it shouldn't work or even be illegal in some way. Am I right? What would happen
you're right.
if he
It's
does
not
this?
legal. Look, we actually, in all seriousness now, we get questions like this all the time during intake. And the question is, look, if I'm going to go bankrupt anyway, what harm is it? And so here's the thing. Number one, if you take out a loan with the intent to not pay it back, whether it's because you're going to file bankruptcy, which is legal, or other reasons, that's fraud because your intent is fraudulent.
Right.
Number one. Number two, if you take a new loan or new credit and then you don't make your first 3 payments, that's considered fraud on its face.
Yeah.
Right. You can't just do that. So yes. And what will happen is the lender, if it's like some hard money loan or some like one of these payday loan places or whatever, they will file a lawsuit within the bankruptcy called an adversary proceeding, seeking to accept that debt from your discharge, which means you may be able to wipe out all the other debt, but that debt will survive.
Oh, wow.
So, and that's what we call an adversary proceeding, and the code section is 523 of the Bankruptcy Code. Exceptions to discharge. There you go. That's a big one.
Yeah. Well, he knew it was dumb.
Yes. Tell your friend that he's probably dumber than he even looks, and don't do stupid stuff. Goddamn, Google it, right? I mean, that's a very simple explanation.
Yeah.
Right? Don't leave it up to your friends to post on Reddit.
I know.
For crying out loud. Okay. Sorry.
I hope his friend was
I'm a little salty today. Just so the audience understands.
Okay. Next one is called My Parents Forged My Signature. Hi.
Sorry.
Hi, I'm 20 years old and I live in Indiana. When I went to college, my father and my stepmother signed my name on student loans without my knowledge. They told me they signed me up for scholarships. I was 17 at the time. My stepmother also filed my FAFSA with her income and not my mother's and caused me to get less financial aid even though I was not living with them. I know, I'm seeing your faces. I took a year off of college and I'm now trying to go back to the same school. But now they're letting me know that I have $15,000 in collections. Their emails were and are still linked to most of my things, including medical bills, which they will not even give me access to. They deposited my tax refund last year into their bank account without my approval and sent me random small amounts of money for 2 months. It's like $20. I just don't know what to do anymore. I live with my boyfriend in our own place and haven't lived with them in over 2 years.
That's a very unfortunate
thing.
So here's the thing. First, I have to give the disclaimer. If they're in Indiana, they're not in California. I'm not licensed in Indiana.
Right.
I don't want this to be construed as me giving legal advice. The question is, what would I do?
Yeah.
Okay. So before I can tell you what I would do, I think that she may have a bad case if she was a minor at the time then minors cannot enter into contracts to begin with,
right,
or those contracts can be voided ab initio, which means like upon the onset. So her parents signing for her may have actually been lawful. Okay. Now, it's morally fucked up for her parents not to consult with her and lie and say, we're getting you scholarships, when in actuality, they just, blew out a bunch of loans to pay her tuition. Now, I can also look at it from a more sensitive perspective, and maybe their thought was, we're just going to pay the loans for her. Right. She'll never know. I don't want her, to have to worry about it. And so maybe their intention was better and they just couldn't afford it, or they missed payments or something happened.
Right.
I'm not sure I understood about the withholding the tax return and giving her $20 here and there, unless that means like her parents got her tax refund.
Yeah, they deposited that in their account.
So that's a different story, because now if she's over 18, that's essentially theft or conversion.
Right.
That's a different issue. I assume that, again, without knowing Indiana law, would Eric sue his mom and dad? No. Would I go after them for that money? No. I would probably just let it go, not speak to him for a while. Yeah. Maybe send him a pretty nasty letter or an email.
And do her own FAFSA too.
Yeah.
Put her own mother.
And what I would do is I would contact FAFSA and any other academic, agency, and let them know what happened, and that I'll be doing this on my own from now on. Right. And please don't give my information out to anybody else or whatever. But,
also, it's weird that still she can't access her medical things because she's 20. I feel like she should be able to access that.
Yeah, I don't know what that's about. Yeah. If there's some kind of financial hold on it or something, or I don't really understand a lot of that question. I understand most of it, but I don't know what the medical records have anything to do with anything.
I think she's just she might be venting and everything else they've done.
Yeah, but that's what I'm saying. Like, what would I do? Probably nothing except notify all these other agencies or organizations of what happened. The other thing too, it depends if she, doesn't really care about a long-term relationship with her parents. Is I do like we see these all the time, these like disgruntled kids that make TikToks about their parents. Like, my mom stole my college tuition and went to like Atlantic City and lost it all, whatever. Yeah, put them out there. Let the world know what kind of people they are. I mean, not that I would do that to my parents, but.
And I remember, don't be like the girl who sued their parents for being born. Remember that one?
Well, that was stupid, right? But I'm saying, this is different. This is actual money. Like, the tax return, for sure.
Yeah.
Like, that's a pretty fucked up thing. And I'm guessing it wasn't tens of thousands of dollars.
No.
Meaning, she's a 20-year-old. Maybe.
But she lives on her own, so she could have used that money.
That's what I'm saying. That the money may have been really significant to her, even though the amount probably wouldn't have killed her parents. So, that's really, really messed up.
Yeah. All right, next one. Was this bankruptcy fraud? My girlfriend and I purchased a house, and during the process, her mom gave her a $10K loan to go towards the house. It turned out, however, that mom is being pursued by credit card debt collectors and is declaring bankruptcy to avoid the debt. I believe that by giving my girlfriend the $10K before declaring bankruptcy, she was committing bankruptcy fraud to try and conceal assets. Mom is expecting the money sometimes back in the future and is requesting some money back already for her lawyer. I just want to know if this is bankruptcy fraud. Would we be found liable of anything? And what are the repercussions to my girlfriend's finances / the house? Would debt collectors be able to request a $10K away from us?
So let me answer that last question first. In that, the answer is no. Debt collectors can only pursue people who owe them the debt, right? If this person's mother unlawfully transferred assets, then that's up to the debt collectors to try to unwind it.
Right.
But that doesn't mean that they can go after the daughter for that money.
Okay.
Is it bankruptcy fraud? That's a harder question to answer, because if the mom discloses on her schedules that she loaned this money to her daughter and that it would be considered an asset, it's a receivable, then that's really all she has to do. The bankruptcy trustee will either pursue it or not if it's worth their time. If the daughter actually put the money into the house, meaning like she made repairs or purchased an appliance, most trustees aren't going to pursue her for that. Right. Especially if it's something that was like needed and a necessity. Again, the mom's position will be, it was just a loan. It's my child. She has to pay me back.
Right.
Okay. The bankruptcy trustee can say, well, if she ever does pay you back, you have to give the money to me, but I'm not going to make a big deal out of it.
Right.
The daughter could arrange a deal with the trustee that says, look, I understand that I may have to repay this because it's an asset, but I don't have it now. I had to buy a refrigerator and fix the stove.
Right.
But I'll give you X amount per month, or make some kind of deal. That's possible too. But there is, again, depending on where they live and how much other debt there is and how many other assets it may be, this may be inconsequential to the trustee. Now, is the mom like a filthy, scandalous person for like using her kid like that? Yes. Like, would I ever do that to my child? No.
Right.
Especially not for that amount. I don't want to sound like an asshole. I know $10,000 is a lot for some people, but I'm just saying, like, I hate to, I mean, I don't want to be a jerk, right? But I mean, I should bigger than 10,000. I don't need to, have a bankruptcy trustee pursue my children or drag them into it. That's really the issue.
Yeah. That's what he's worried about.
Yeah. And that's really the issue is the amount doesn't justify what could happen. And she may have to get her own lawyer to deal with the trustee. So that's just, that was just kind of nasty.
Yeah.
But the correct thing to do, the mom should list it as an asset, show documentation, like here's the money I wired or here's the check, and let the trustee decide what to do. It's not fraud if she discloses the debt.
Right. Okay. Is it considered fraud to file bankruptcy after signing a lease? I've come under some financial hardships that have gotten so bad that I've had to make the unfortunate decision to file bankruptcy as I can't afford it. Alongside that, I was needing to find a new place to stay since my landlords aren't renewing my lease in December. I visited another complex and got info about everything there, and they happened to mention that if I were to apply, I would automatically be denied if there were felonies, due payments from other landlords, and more importantly, a bankruptcy on your record. So my question is, if I were to apply and get approved for the apartment, but file right after I move in, would that be considered fraud?
That's a hard question to answer, but my I don't know what state they're in or anything like that. What would Eric do? I don't know. I'd probably go for the apartment and wait a few months.
Yeah.
And then file. I mean, it takes time for credit card companies to like actually sue you. So you can send a letter. You put it in writing saying, I only wish to be communicated with in writing. I don't want any phone calls. They have to respect that. That's part of what's called the Fair Debt Collection Practices Act.
Right.
So under the FDCPA, bill collectors can't harass you or give you phone calls if you tell them not to, but you have to put it in writing. Send them all letters. Guys, I only want to be communicated with by mail. And then don't do anything for a few months.
Yeah.
It'll take them time to actually get a law firm, file a lawsuit, and even if they get a judgment. So what? It's not a fraud judgment. It's just a credit card debt.
Right.
Right. In the meantime, after you get a lease and after you pay your rent, you can file. You can reaffirm your lease. You can keep it and just keep paying your rent. And it's for an apartment. You can do it for a car too. You can keep a car after a lease also in bankruptcy. Right. So I would just say if he's going to be denied a place that he really likes just because he filed, I would get the place first and then I would wait a few months, file it after. Not right away, like not the next day.
Right.
What would Eric do? Eric would wait and file like in 3 months.
Okay. Next one. Parents are going to declare bankruptcy and they're using my bank account to hide money. This is a throwaway account for obvious reasons. My parents are going to declare bankruptcy and they have been using my bank account. I'm over 18 and their names are not on my bank account. They use it to cash their checks and withdraw the cash to hide it from the government. They've been depositing checks into my bank account and are having me sign a bunch of blank checks which they cash for themselves in the amount that they deposit. What kind of legal trouble would this get me into? And what kind of trouble would it get them into? Thank you for all your help.
Okay, you're welcome. Although I don't think you're going to find this very helpful. But here's the deal. Everybody's guilty on this one.
Yeah.
Okay. The child is complicit, assuming he's an adult.
Yeah, 18.
Yeah. Okay. I know an 18-year-old is legally an adult, although if he lives at home and he's under his parents' roof, he's probably just trying to be a good son or a good daughter, and kind of doing what they say. But they would essentially be an accomplice in that is bankruptcy fraud if you are funneling money and hiding it and then making your son write checks to cash.
Yeah.
If the trustee finds where the money is coming from, I don't mean the cash checks. I mean, how is money getting into the kid's account? It's got to be going somehow.
Yeah.
Now, if the parents are stupid enough to have their work direct deposits directed to their kid's account, then honestly, they deserve whatever they're going to get.
Well, no, I think they're depositing checks and then just.
Well, but that's the question. Where do they earn their income and for what? Right. If they're what we call under the law, under bankruptcy code, if they're called wage earners, right, then your wages are exempt. Nobody garnishes your paychecks in bankruptcy.
Right.
You may make too much for a Chapter 7. You may have to go into a Chapter 13 and repay, a part of all your unsecured debt. But you're not denied bankruptcy because you have a certain income.
Right.
It's only a question of what chapter you can file and who gets paid back. So the bankruptcy code is actually really fair. In that, if you have less than $100 a month of disposable income after all your expenses are paid, and when I say all, I mean like your cell phone and cable, groceries, gas, insurance, I mean everything, right? Then you file Chapter 7, doesn't matter, right? It's okay. And even if your income is higher than the means test, if your expenses are reasonable and justified. So if you own a house and your house doesn't have more than $600,000 in equity, and you want to file Chapter 7, you can. Even if your mortgage payment's $15,000 a month and you make $20,000 a month, you can, because so much is going to an actual valid expense.
Right.
So it is really, really stupid if they're funneling payroll. Now, if, like, say, for example, they're self-employed, right?
Right.
Now we have a different question, because they're going to, at some point, they're going to want to know how they're surviving, right? They file bankruptcy. Trustee says, what do you make for income? Well, we're self-employed. Okay. Self-employed people have to provide 12 months worth of bank statements and last couple of tax returns. Trustee's going to want to know, well, how come all of a sudden you stop? There's no more deposits.
Right.
Like, are you earning any income at all? What are they going to say? They're either going to say, no, we're not earning any income. Okay. How are you paying rent? How are you buying food? Or they're going to say, well, we're getting less income. And because there was a judgment and our account was levied on, we're using our son's account, but then the trustee's going to want to see all of the son's bank statements. So all in all, this is a pretty messed up situation. Chances are that everybody will get in trouble for this. The son could unwittingly be kind of accomplished and subjected to whatever the bankruptcy court's going to do. So I were him, I would make that practice stop.
Right.
What would Eric do? Eric would tell his parents no more. Eric would open a new bank account completely separate from all of it.
Stop signing checks
and tell his parents, you're not going to do bankruptcy for at least another year, 9 months, whatever. Time has to go on. That's it. That's what Eric would do.
Okay. Excellent. Is this bankruptcy fraud? Location is California. I loaned my brother $15,000 for fertility treatments. My parents wanted grandchildren, and I'm not planning to have any, so I agreed to loan my brother the money in hopes of a niece or a nephew. Don't say it goes downhill. We signed a contract, agreed no interest on the loan, and a minimum payment of $200 a month. The loan also excluded his wife from the debt. In the end, they didn't have a baby, and the marriage suffered as a result, and they were divorced by the next year. Everyone was very sad, including me, and I offered to forgive $5,000 off from the loan. My brother said it was his responsibility and that I worked hard for that money and he would eventually pay it off, but to give him some time. By the start of this year, my brother had made around $9,000 in payments and owed a balance of $6,000. He got a new job and was getting paid more, so we both expected him to meet his obligation by the end of the year. In February, he met another woman. They married in April, and he stopped making payments to me in May. He told me he can't afford to pay the loan anymore. Maybe that is true, but my brother and sister-in-law are living a lavish lifestyle. They've taken several vacations during the summer. She buys designer clothes and just had plastic surgery in October. She had her breast, tummy, and nose done. When my mom asked how she was able to afford the surgery, she inadvertently disclosed to my mom that they intend to open as many credit accounts as they can, charge them up, and then file for bankruptcy. She also told my mom she doesn't think that she should have to pay for his loans from his previous marriage and that his ex-wife owes me the remaining balance. I'm pissed, but I understand I may never see any of that money that my brother owes me. But is it legal for them to use bankruptcy like that?
That's a really upsetting question on a lot of levels. So let me start by saying, like the last part, that the new wife is correct, that it is not her legal obligation to pay his loan that was before they met or prior to their marriage. That debt would not be a community debt.
Well, I think she meant, and regardless, like now
I understand what she meant. But fuck her. I'm just explaining, okay, because she sounds like a terrible human being.
Yeah.
But I'm just explaining that legally, she has no obligation to pay a loan that her husband took before they got married. Okay. The brother, on the other hand, I think, okay, you're asking what would Eric do? Eric is very close with his brother. Eric has had some scrapes with his sister-in-law's sister, not his sister-in-law necessarily. But I understand. But so what Eric would do, just to preserve his relationship with his brother, is I would just forgive the balance and say screw it. Now, is it bankruptcy fraud to open as many credit cards and personal loan accounts as you can, bang them up, and then file bankruptcy? Yes, if your intention is to never repay them.
Right.
The other issue that most people don't think about is that what you put in your credit application is essentially a sworn statement under penalty of perjury. Has the same effect. So if a lending institution or a credit card company extends credit to you based on the information you provide, and that information is knowingly false, like you put down you make $150,000 a year and you only make $50,000 a year, and it's not a typo, then that's fraud. And they can try to accept from discharge those debts, even if they make the first few payments, right? So all around, this sounds like a very cunty person who, now look, we don't know them personally. We don't know if she really is rolling in designer clothes,
right,
or whatever, or if like designer for them is like Kohl's, like whatever, like a Target or whatever. I don't know. It is for. I'm not trying to make fun. I'm just saying we don't really know what lavish lifestyle means.
Yeah,
a lavish lifestyle in Hesperia is far different, than a lavish lifestyle like in LA, right? So,
well, they said they've been on vacations a lot.
I understand, but okay, Palm Springs is a vacation, so is Italy. I mean, I'm just saying everything is relative.
Yeah, no,
right?
yeah.
So, but my point is this. I think that if I were the brother, I would still pay my brother back because this was meant to, bring a child into the world. Right. And this was for good, beautiful purpose and for reasons. This wasn't like, hey, I'm in trouble with a bookie, and then 2 weeks later I'm still betting on sports. It's not like that.
Right.
So that's what I would do personally. Even if I went bankrupt, I would figure out a way to pay my brother back separately on my own. I would reaffirm his debt, whatever. Okay. Other than that, what else would I do? I would let it go. And again, he can't control what his brother does. Sounds like his new sister-in-law's a bitch.
Definitely.
But whatever, they're going to make their bed and they're going to lie in it. If they're stupid enough to run up a bunch of credit and just think that nobody's going to notice, then okay, take your shot. And by the way, any competent lawyer that they go to for bankruptcy is going to see all these statements. Yeah. He's going to ask, when's the last payment? When's the last time you used this card? When was the last time you made a payment on this card? What were you purchasing? Because that goes back to if they bang up a bunch of lavish stuff, watches, TVs, right. That's fraud. If the credit card debt is used for everyday living expenses or necessities, food, gasoline, clothing, things like that, they can probably get away with it.
Right. Okay. Next one. Contractor scammed animal rescue, filed bankruptcy, and then committed fraud. I guess. Okay. That's the title. That's the title. I run a 501c3 animal rescue. We hired a contractor to renovate our outbuilding. He took a deposit, then kept delaying the start date. Finally, he just stopped responding. We literally never heard from him again. We tried to serve him but couldn't find an address and then received a bankruptcy notice in the mail. According to the bankruptcy submission, he owes $200K to various creditors, including many homeowners who he did the same thing to. I've spoken with some of these homeowners, and to say that they've also been massively affected by this contractor's action is an understatement. In the bankruptcy submission, the contractor listed that he had no firearms amongst his assets. I found this unlikely as he is an ex-military hunter. I spoke with a fellow creditor who was a previous friend/employee of the contractor, and he told me the contractor had a large collection of guns. I informed the trustee. Yesterday at the meeting of the creditors, which I attended, the trustee questioned him on the guns, and he admitted to owning one or two, as if someone doesn't know exactly how many guns they own, unless they have a ton of them. Doesn't this constitute bankruptcy fraud? How do I pursue this? I would love to recoup some of the rescue's money because people donated that money, but I've pretty much given up hope on that. So at the very least, I'd like to see some sort of penalty for his behavior. He is currently unemployed and has been for months. The only gig he's had recently was in the contracting business, but it seems like he did a little of legitimate work. It's heartbreaking to know that he gets to walk away from this after taking money from hardworking people.
All right. I don't okay.
That was it. Okay.
All right. Sometimes people just write too much.
Yeah.
So here's what Eric would do. Okay. Eric would file what's called an adversary proceeding in that contractor's chapter 7. And I would seek to accept from discharge the debt. I would also file, that's under what's called code section 523. 523 deals with individual creditors and their debts. Okay. But you can also file an adversary proceeding under what's called section 727, which would be to deny his discharge to all the creditors. And any one creditor has standing to bring that kind of action. And the fact that he omitted assets out of his bankruptcy is enough to do a 727, right? And that would not only make the animal rescue's debt dischargeable, it would potentially make all of the debts dischargeable. So if he really wants to punish this guy, jail won't help because he'll never be able to make money and pay anybody back. But you make it so that he can't discharge and wipe out all these debts. He's going to owe money to all these people, then sue him or get a judgment, or then get a judgment in the bankruptcy court for non-dischargeability or whatever, and stay after him. Send him to a collection agency. Haul him in for a judgment debtor exam. No, if look, Eric also can be vindictive. Okay. If I feel like somebody has done something super wrong, especially to one of my clients, yes, I have been known to be really, really savage. And this is a case that I would probably do that for if the animal rescue was my client. Right. Because it's a nonprofit. It's meant to try to deal with stray animals and help the animal population by neutering and spaying and all that kind of stuff. These animal rescues are unsung heroes in a lot of ways. Literally. So it's bad enough to knowingly take money and not be able to perform work or rip anybody off. It's a little bit worse in my book if you do it to an organization that depends on donations, that doesn't have a big stack of money. So, for example, I have one client, I can't name his name, but he has no issue whatsoever like scamming an insurance company. Because his position is insurance companies do this to people all the time. They routinely deny claims that they shouldn't deny. They collect your premium. They cancel you if you're a day late. They don't give a shit. And then, but when it comes time to pay, they look for every reason not to. Okay. But this is not an insurance company, right? This is a pet rescue. Give me a break.
Literally. All right. Last one. My parents want to transfer their home to me before filing bankruptcy. Isn't this fraud?
Yes. Don't do it. Stop. That can be undone.
Hold on. There's more to this.
All right. Sorry.
So my parents have a $500K debt. They own a home that's worth around $800K, a car worth maybe 20, and another car worth probably 10. They make $50K annually, and that's combined. My dad's planning to retire ASAP, but he has zero savings. I live in a different state and have no assets, and I make only like $70K annually, and I just graduated from college. My parents went to a bankruptcy lawyer, and he told them that if they transfer their home to me now, they can file bankruptcy in 7 years and not lose the home. The logic being that the look-back period that is reported is 6 years, so my parents would not have to disclose that they transferred me the home. My parents had a different lawyer draft up a document where I'm the owner on the deed, but my parents still have financial responsibilities. They're going to be paying the property taxes, and it will show up on their tax returns. My parents will also be tenants in the home for as long as they live. They are pressuring me to sign this document. If my parents live in the house, which in the clause in the deed, it's wrote up in there, and still pay property taxes on the house, which is in the deed's transfer as well, wouldn't this be caught immediately as fraudulent?
Not necessarily. So we've seen similar instances here, but in our client's case, there was a prenuptial agreement. We waited to file for 4 years, or he waited till the house was transferred after 4 years. So when we filed the case for this particular client, the 4 years was up in a few months. So we waited a few months and then filed it. So they couldn't go back and undo that. What you're describing is something called a life estate, where in real estate, I can give a life estate to someone from my house and say, you can live in this house for as long as you are naturally alive. All right. And you can never be kicked out, and that's it. But the house belongs to me, but you can live in it throughout your entire life, up until the day you die. That's a life estate. And that's essentially what they're saying they would get from the son. They're going to transfer the house to the son. He's going to give them a life estate. And in exchange, they're going to pay the property taxes or make mortgage payments or whatever. It sounds okay in theory. I don't know what state they're in. I don't know what the...
Didn't say.
Well, that's the other question. Yeah. What is the homestead exemption amount in the state they live in? So if their house is worth $800,000 and they owe zero, then nothing's going to help. If they owe 300, right, and it's worth 800, and they live in California or in Los Angeles, where the homestead exemption can be 600,000, they can still file and not do anything. Right? They can exempt the equity and keep it. Their income is not too high. 50K combined, for even just for two people, is well within the means test. They're not going to have an issue with that. So again, depends on the state they're in. Right. But the answer is they could do it. And yes, the 7-year period would be like they don't have to disclose assets transferred within a certain period of time. It's a little contrived, and the trustee is going to see that they pay the property taxes on the tax returns, or they take a mortgage interest deduction of some kind or something like that. So they're going to have to explain that. And that might be a little bit difficult to explain, because I think most trustees are going to see through and understand what they did.
Exactly.
But just because something is less than ethical or planned strategically doesn't make it illegal. So what would Eric do? Eric would probably be okay with it.
Okay. Well, I think that wraps up our episode. So thank you guys for listening, and follow on wherever you guys listen.
By the way, my dad joke was way better than yours.
My dad joke was better. I had another one. Do you want to hear the other one?
Okay, go ahead.
Did you know that the first French fries weren't actually cooked in France? They were cooked in Greece. See, she laughed. You're laughing. Exactly. You see?
Did you see that news feed about the actress that was stabbed?
Which actress?
Reese
Witherspoon.
No, Karina, with a knife. See, thank you. Eric always wins.
In the background laughter, that's Jennifer, guys.
We do have her. I know. We do have by the way, we have a new slogan.
Oh yeah. You want to say?
Oh, money gone, then Sama gone.
Exactly.
There you go. That's right. If you're out of money and you need to go bankrupt.
And we need money right now. Holidays are coming up.
That's guys. Right. Money gone, then Sama-con. We'll get it done.
All right. Well, thank you guys for listening. Follow us on Instagram at the Bensama Confirm, on Twitter and TikTok at the Bensama Confirm. Website is eblawfirm.us, and you can email us at info@eblawfirm.us. Bye.
Bye.